Hello, and you're very welcome to episode 5 of The Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
And myself, Mark Tottenham, barrister and editor of Decisis.ie.
Good to see you, Mark. On last week's show, you may remember we had a wonderful chat with family law solicitor Keith Walsh. Got a great reaction to that.
Yeah, absolutely. I mean, he really did sort of lift the lid on the family courts. Yeah. And in particular, obviously, the fact that because they're in camera, there's so much that a lot of people just don't hear about.
And he wasn't buying my argument that it's full of emotion and that, you know, you're part a counsellor and stuff like that. Yes, there's an element.
He seems to be able to leave things behind at the end of the day.
He's a professional solicitor.
Yeah.
I want to learn from that man. That's the way to do your job. No, he was really, really impressive. And I found that really, really good. Okay, well, this week we shift our gaze in the direction of criminal law. And with all the attention the Hutch Trial is getting at the moment, we thought we'd take a closer look at the Special Criminal Court and the role of the Witness Protection Programme. And we're delighted to be joined in studio today by criminal barrister Katherine McGillicuddy, who's going to talk to us about those issues and other criminal matters as well. I'm really looking forward to that chat. But first, Mark, as always, you have identified 2 very interesting cases from the Decisis website. The first is a PI case with a very interesting backstory. It involves a bull and a mart. It's a decision for Mr. Justice Ferreter in the High Court. Can you tell us more?
Yeah, well, I know our producer Connell doesn't believe in acronyms. So a PI case is a personal injuries case, and it was a case involving a bull that was out a mart, as you say, and it was run with a number of other animals into a crush or a run. And the problem is, obviously, when you're putting cattle into a, I'm sure you've experienced this.
Yes, I was going to say, the way you said it there, it sounded like you're a great expert.
I did herd cattle quite a bit as a child.
I could see it all, yes.
But it's very often what happens is you get an animal gets its head stuck in the railings of the run and they can't go through. And so what happened in this case was that the operators or the people in charge of the mart decided to effectively reverse the animals out. Now, that's not an easy thing to do. But the problem was that because one of these was a bull, and as you know, bulls are not as easy to handle as bullocks or cows, they tend to get agitated. And the person here, the farmer who was involved in the mart, was attacked and gored. And he suffered nasty injuries. And there was an accusation that he had in some way aggravated the bull himself by his use of a stick. But I mean, I think the worst you could say is probably he was trying to defend himself. In any event, it was accepted by Mr. Justice Ferreter that the mart was negligent in the way that they handled it.
So the issue was, at what point did the bull transfer from his ownership or his responsibility to that of the mart? So Mr. Justice Ferreter said, you know, once he goes into the pen or once he goes into the crush, as you described it, that's when the mart takes over and that's where the responsibility is.
I think there's a wider issue, which is the safety of the system involved. You know, once you have a number of animals in an enclosed space, you do require the people who own the mart to operate it properly.
Okay, €75,000, that was the award in this case.
That's right.
There was, obviously, he damaged his ribs. It was a very serious injury. I mean, you can just imagine being gored by a bull. And obviously, there was PTSD, post-traumatic stress disorder as well. So he got some compensation for that. Do you know how the compensation broke down?
No, I don't have that.
Okay, but just we can understand why there would be an extra element for PTSD. Okay, really, really good case and really interesting case, Mark. Okay, next to a very interesting asylum decision. And this concerned a judicial review application of a decision of the International Protection Appeals Tribunal made in respect of an Indian national. Ms. Justice Phelan granted the relief sought on the basis that the tribunal had not fully taken into account very, very specific, in this case, country of origin information. Obviously, with asylum seekers, country of origin information is always central to their claims. And this case, it was very, very specific, Mark. Can you tell us about that?
That's right. Well, by coincidence, this also involves the cattle trade. Now, as we know, obviously, in India, Hindus consider the cow to be a holy creature. But India also has a very sizable Muslim population. I think it's about 200 million people. And Muslims obviously are allowed to eat beef. Now, there are some parts of India where cow slaughter is banned altogether, but there are other parts where there's a reasonably sizable beef industry, and Muslims, for obvious reasons, tend to be involved in that. This particular applicant had come to Ireland saying that because he was involved in the beef trade, that he was at risk of persecution. And what the International Protection Appeals Tribunal found was that he could have relocated within India to avoid the persecution. And so that was the issue that came up. Now, again, India is a huge country. Obviously, in theory, he might have been able to relocate, but also it's worth saying that Muslims tend to be quite widely spread throughout the country. It's not as if there are large Muslim areas, or in particular.
But also a factor in this case was that was his trade, that was his job. He was a butcher, or maybe not a butcher, worked in the meat industry. That's what he did for a living, and to practice that anywhere within India was potentially problematic. That was his point.
Yeah, and I mean, I think there's obviously a big issue in India these days because there's a Hindu nationalist party in government, and so things have got much less pleasant for Muslims living in the country. But in any event, what the court found was they hadn't given sufficient attention to the issue of internal relocation within India, and that the finding that they should have had more information to hand before they determined that he could have avoided persecution by relocating.
Yes, no, it's really interesting. So there was a kind of a combination of country of origin information coupled with the specific circumstances. I suppose that always applies, but in this it was very specific, and it's a very interesting decision from Ms. Justice Phelan. Okay, we've only 2 today, Mark. Normally we have 3, but we've only 2 today, so that's it. We'll whet the appetite for next week. We'll be back very shortly with barrister Katherine McGillicuddy.
Silence in the Fifth Court.
It's my great pleasure to welcome to the studio Katherine McGillicuddy, criminal law barrister. Amongst other things, Katherine, I know you have other areas of practice, but you're well known for your practice within criminal law.
And thanks very much for having me on, Mark and Peter.
Delighted to have you in. And, at the moment, criminal law is everywhere. It's everywhere all the time. But obviously the Hutch Trial has attracted a lot of attention to the special criminal courts. We thought maybe we might talk about that a little bit. So generally around the courts there in the Phoenix Park, what's the vibe with this Hutch Trial? Is it capturing the imagination of you criminal legal practitioners as well?
I suppose there's a lot of security around the building at the moment, but that would be not particularly unusual if there's a case in the Special Criminal Court. It's, I suppose, heightened maybe, especially at the front entrance at the moment. So the Special Criminal Court would always have a guard presence outside. They would take a note of any person who wanted to enter the court, just take their name, details. They might ask them what's their interest, but that has historically been the position. And I suppose there's a bit of a buzz in terms of journalists' interest in it. And
it's going to last for weeks and weeks, Katherine.
It is. It's only just started. It's very early stages in the case. So at the moment, it's kind of the introductory thing. So I think it will take a while before let's get into the Special Criminal Court and the way it goes about its business. But one of the first aspects that emerged in this trial was the witness protection programme. There was a witness, somebody who was convicted, but got a lesser conviction because they were participating in terms of state's evidence and the witness protection programme. That's relatively novel in Irish law, isn't it? Well, we've had witnesses going into the witness protection programme probably since the Veronica Guerin case. That's probably the first, the genesis of it really in Ireland. And I suppose each case is different. Sometimes you will have people who are just protected witnesses because they have serious evidence to give, but they can stay in Ireland and live their lives as normal, perhaps with a better security system installed in their house, maybe CCTV cameras. Other times it's more nuanced or difficult. In this, or in some cases, you might have a situation where a person is charged along with other people, and then they make contact one way or another with a view to entering the witness protection programme.
Okay.
And then a number of different things could happen. A proposal might be made that they might, enter a guilty plea to a particular offence, make a statement and seek to be admitted to the witness protection programme. But the order of those things might vary. Obviously, in terms of pleading guilty to a lesser offence, that's something that the Director of Public Prosecutions would have to consider.
Yes, so they'd have to be all over that. The DPP has to be across this. It's not just the guards.
That's right. And it's not a foregone conclusion that somebody would automatically be a plea to a lesser offence would be accepted.
Yes.
That would depend on the circumstances of the case.
Okay. And in terms of, let's say, have you had direct experience of this? I don't want you to go into any specific cases, but you have had direct experience.
I've seen it, saw it in an ordinary murder case in the Central Criminal Court a long time ago, where the witness who'd entered the programme was involved. It was alleged that he was participating in maybe the lead up to the murder in terms of movements of vehicles, if I can put it that way. And he effectively approached, through his solicitors, the Gardaí with a view to entering the programme. He then gave evidence against the co-accused. And certainly at the trial, one of the notable things for me was that there were two accused, they were in difficult circumstances in that they were people who had suffered from addictions. And this person who had gone into the witness security program, as it's now known, also had suffered from addictions, but by virtue of the fact that he had now gone into the program, his presentation was entirely different.
Okay.
It was clear that he was somebody who was now clean.
He was in a better place.
Absolutely, visibly so. And one of the, I suppose, features of this is that people will wonder, well, what are the terms and conditions of that person's entry into the programme?
Sure.
Have they gotten financial assistance? Have they gotten healthcare or addiction help and treatment? And, if there's any incentives or inducements offered to them.
And is much known publicly about how the programme works, or is it generally shrouded in secrecy? I mean, we do know that there's cooperation, certainly between the Gardaí and police in other English-speaking countries in terms of resettling people and giving them a new identity and that kind of thing, don't we?
Well, the programme is not on a statutory basis. I think that a good deal is known about it in practice because it does come up from time to time. In terms of the personnel that are involved, it goes to quite a high level inside the An Garda Síochána. Ultimately, an assistant commissioner is involved in the process. And we know that the criteria would have to be that the alleged crime is something that's serious, that the person has evidence of real significance, something that would make an impact in respect of the prosecution case, and also they're at risk.
Yeah, we're effectively talking about organised crime and paramilitary organisations, aren't we? I mean,
oftentimes, but not necessarily so. It could be just a very serious crime, and that somebody has evidence that really is very significant in respect to the case, and then so they look at all of those features, and also the person themselves, their psychological background, how they would fare out in a programme. What kind of assistance would they require? What can be offered to them?
In fact, when you talked about the statutory basis, I think the only statutory provision is one that's designed to prevent anybody actually trying to identify somebody who's on a programme. Isn't that right?
That's right. So if a person were to take steps to try and find out where a witness was, that's a criminal offence. Yeah. Or if a person who had information about the witness in the programme and disclose it, that's also an offence.
Okay.
And I suppose those are subspecies of a common offence, which is intimidation of witnesses, which we've had since 1999. So this wouldn't be anything groundbreaking or anything unusual. It would be in keeping with that type of provision.
Okay, really interesting, Katherine. And as you said earlier, there has to be buy-in from a number of different parties that are involved. Obviously the guards, the DPP, but also the court. And this is the bit that kind of strikes me in terms of separation of powers. So at a local level, maybe the Gardaí investigating something and maybe the DPP allowing the individual to plead to a lesser charge. I mean, the court is separate. The court is separate in terms of imposing a sentence. So how does that work?
Are you saying just in respect of the sentence that the witness has pleaded guilty to?
Yes.
Just that aspect?
Yes.
Well, I suppose...
the court has to be free to impose whatever sentence the crime merits, presumably.
That's right, because obviously the court sentences number one, the offence before it.
Yes.
So if the person has pleaded guilty to a particular offence, the court will ask, okay, what is that offence? Are the facts and circumstances around it?
Yes.
What are the maximum penalty? And then also, what are the personal circumstances of the person whom they are sentencing? And
there'll always be mitigating factors, I accept that. Yeah. But is there not a separation of powers issue here?
But in what sense?
Well, in the sense that it only works, I would imagine the witness protection programme works, if all the parties buy into it, if you know what I mean. You know, that there is going to be a lesser sentence at the end of the day. Or can you guarantee that?
No, I wouldn't.
Maybe I'm jumping ahead.
I don't think that's the case, because I think the ordinary sentencing provisions apply. You sentence the offence and the offender. It might be something that the court is asked to take into account, the fact that this person has given information and now now they are being sentenced, and the court is obviously open to giving them whatever sentence they want. But if the court is minded to give them a prison sentence, then of course they might say, well, prison is going to be more difficult for this person because there may be safety and security concerns for them in custody, and also because they're entering this programme. They're going to have to make lifelong changes to their life on foot of the information that they have given. And this is something, maybe a hardship that the court may or may not take into account ultimately.
So there's loads of factors, that's what you're telling me, and that's the way it works.
And ultimately, when that witness comes to court later on a separate occasion to give evidence in whatever trial they are going to be giving evidence in, the fact that, for example, if it is the case they've pleaded guilty to a lesser charge and got a particular sentence for it, all of those issues will undoubtedly be explored by the defence. And ultimately, whatever court is dealing with that offence, they'll see the witness, their credibility will be tested. The fact, it'll possibly be put to them that, well, you had skin in the game, you were in trouble yourself, you decided you were going to save your own neck, and you saw an opportunity to drop other people in it. Nothing you say is reliable. Your credibility is shot, and you only got a short sentence, and you wanted out, something along those lines. But and also ultimately, so the court will hear all of that. They'll see the witness. They'll see for themselves what credibility they want to. The judge or jury, as the case may be, and ultimately, when the court is coming to determine the case, whether it's judges or jury, there's a warning given in respect of the witness.
Yes.
So there might be an accomplice warning if they were accomplice, or there might be a warning given to reflect the fact that this is a witness who maybe their testimony should be approached with a degree of caution, and to remind the ultimate triers of fact in the case that this witness's testimony may not be totally reliable, and to take that into account when ultimately determining the case.
Brilliantly explained, Catherine. Can I just ask, Mark, do you want to come in there?
Well, I was just going to ask, when you talk about the ultimate triers of fact, I mean, would protected witnesses largely be giving evidence in the special criminal court, or would you find them before juries in ordinary trials?
You can find them before ordinary juries. I've seen that myself, but I suppose most often in the special criminal court. And obviously the point you're getting to is the fact that there's no jury in the special criminal court. You have 3 judges who are the judges of law and ultimately the judges of fact. So they are judges and jury in the same case. So they are effectively professional jurors.
Yeah.
And but the same principles apply. They see the witness, they hear their evidence, the witnesses are tested, whatever material the defence wish to put to them is put. And ultimately, when they come to deliberate on it, they are told to warn themselves about the risks of evidence being given by this person, that it might not be reliable.
Okay, and we know that Mr. Hutch, in the case we're talking about, fought hard to have his case heard in the Central Criminal Court before a jury. And, if you look at the statistics and if you look at the sort of the results that come out of the Special Criminal Court, can you understand why he might have fought like that?
Well, I suppose the case that Hutch and Dowdall brought challenging the Special Criminal Court was slightly different. There's been a number of different challenges over the years, and one of, I suppose, the aspects that they were zoning in on was that the current Special Criminal Court is really in operation since 1972 and being renewed on an annual basis. And the idea being that in the 70s, when it commenced, this particular Special Criminal Court, was that we had a particular landscape politically, in that there was a provisional activity with the IRA.
Paramilitaries, of course. Yes.
And that climate has dissipated, and we're now over 20 years since the Good Friday Agreement, and that same impetus for that emergency type of landscape is no longer the case. So that was the focus of that particular challenge, and ultimately was rejected by the Supreme Court on this occasion. So I suppose ultimately we have a provision in our constitution enabling special courts or emergency type of courts, and that is the basis for the Special Criminal Court, and it is I suppose put forward before the Dáil year in, year out, and renewed annually. So at the moment it is being renewed. I don't know down the line whether that will change.
Yes.
Obviously it is something that is really roundly and heavily criticised by the Irish Council for Civil Liberties and other bodies for a very long time. But
Sinn Féin, for example, for a long time, that was their policy. I think they're rolling back on it now,
so
but anyway.
In recent times, they have taken the approach of abstaining from the vote in the Dáil, and I think they've had a motion in their Ardèis in the last few years where they have rowed back against that absolute, opposition to the court. So, I mean, there's a review of the court happening at the moment. I think retired Judge Michael Peart is overseeing that.
Yes.
So we'll just have to see how it plays out. Obviously, trial by jury is considered to be, a fundamental constitutional right and part of fair procedures that you're tried before 12 people picked at random from the community. The idea being that ultimately they decide, your peers decide whether you're guilty or not guilty. And that's always seen as a fundamental right. As against that, there's particular people who are in favour of the Special Criminal Court would say that there are particular security concerns in this state, whether it be from provisional, or paramilitary type of organisations, or from serious organised crime that merit the continuance of the court.
Okay, no, really good. And just in terms of how it works, as you explained brilliantly that the court serves as both judge and jury. So the three members of the court serve as judge and jury. How do they wear those different hats?
Well, undoubtedly there's an element of mental gymnastics required by the court. So, for example, if a legal issue arises normally in a criminal trial, that legal issue is determined by the judge alone. So the jury are asked to leave the room. And they're told about this at the start of every case. Look, a legal issue might arise. You'll be asked to leave the room. It's not because we're doing anything behind your back. It's because the judge must deal with the legal issue, because the law is for the trial judge and the facts are for you. So once we've determined the legal issue,
yes,
you'll be invited back in and the case will continue. So, and I suppose part of that is to make sure that no inadmissible or irrelevant evidence slips into a trial and that the jury hears something that wouldn't be fair.
Yes, of course.
So that is the thinking there. Whereas in the Special Criminal Court, because the judges and jury are one and the same being, there is no leaving the room, coming back into the room. They're asked to effectively press pause on their jury role, deal with the legal issue, and then when that is dealt with, continue as though we're now judge and jury mode again. And I suppose there's always a risk because of human error that the court might ultimately, when it reaches its decision, have regard to something that happened in that legal issue. So the
information that was in that voir dire type scenario is lingering in the back of the mind and therefore has an impact. I mean, how can you judge that? You can't.
One of the ways you can judge that is that the Special Criminal Court delivers a written judgment and certainly explains its reasons. So that's always available. So you'll have, when I say the judge will have written out a judgment and delivered it. So there's reasons for the decision available to the parties. And that's different to what happens in a normal jury trial where all you will ever hear from the jury is guilty or not guilty. That you'll never hear from a jury, well, we found the CCTV evidence particularly compelling and that's what led us to find the person guilty, but we weren't that interested or compelled by
So the written decision is very helpful. And I suppose if there's an appeal issue then down the line,
they pronounce the reasons for their decisions and that's available then.
What about, was it ever mooted that there should be a sidebar court? Maybe a judge sitting alone who can deal with legal issues that arise, and then let's go back before the judge and jury, the three members, in order to consider the facts of the case.
I'm not sure if it's ever been mooted, but I suppose when you say that, the practicality of dealing with that, it seems quite difficult in that what you would have then is, legal issues kind of don't exist in a vacuum. So the legal issues must always be considered in the context maybe of the particular case.
Yes,
so
of course.
If you had
and by the judge.
Yeah, so if you had a separate judge dealing with a particular legal issue, there would be a lot of information that might have to be, relayed to them before they could really grasp what that's about. So that might be
highly
quite
impractical.
slow.
highly impractical.
Well, look, I mean, it maybe could work. I suppose it could possibly work. I'm not aware of it ever being mooted in that context. And obviously, the Special Criminal Court is a 3-judge court. So the idea of one judge dealing with a particular legal issue, is even less attractive, I think, as a concept, particularly to the defence.
Can I move to another issue? I think there was a recent judgment where a jury conviction was set aside because the trial judge had been asking too many questions during the hearing. And the suggestion was that by asking a lot of questions, particularly during cross-examination, he was effectively putting the cross-examiner off his or her stride and I suppose possibly indicating some kind of indication of his own view during the questioning. Was that part of the consideration?
Well, I suppose that the issue of intervention by trial judges has been something that comes up occasionally. It's not a common occurrence here. Certainly I'm aware of it occurring in a judicial review context where effectively the DAR, or the transcript of the hearing in question, was reviewed by the High Court and they were satisfied that the level of intervention was excessive and then that deprives the accused person of a fair trial. And that, I suppose, is ultimately what whether it's an appeal court or a review court will be examining. And it's an unfortunate issue when it happens. And in fairness to all, I suppose it's difficult to stop a judge asking questions. Sometimes the question is just exactly what the jury might be wondering about themselves. And I suppose it's just a very unfortunate thing when it happens because it's actually nobody's interest that it happens. It's not the accused person or the victims, because more often than not, the outcome is that the case must be retried, and that is difficult for everybody. But judges are human too. It's unlikely that any judge would get into the seat in the morning with a view to scupper something. That just doesn't happen.
Yeah, no, but clearly it's one of these issues that comes up from time to time. And I suppose when a decision like that is made by the Court of Appeal, it just reminds everybody that the primary movers in terms of asking questions are the counsel rather than the judge.
That's right. But I mean, like I say, it's very difficult to stop a judge from asking questions or to say to a judge, that's too much. Ultimately, they are there to, ensure there's a fair trial. And, if they have a question or if there's something they didn't follow, oftentimes it's useful because the jury might be thinking the exact same thing. So, look, it happens. It's not common, thankfully. And it is, it's unfortunate because it puts everybody through the process a second time.
Yeah. And another issue that I know is in the press quite a lot. It concerns the availability of criminal legal aid we've heard obviously in the UK there have been strikes, and it's got to the stage where there are people saying it's simply impossible to get people to act in criminal cases. I don't think the situation is as acute here, but they did reduce criminal legal aid, I think in 2009, 2010, and it hasn't come back up again. And do you think that's having an effect on the criminal bar?
Well, yes, I think is the short answer. The UK is slightly different. They went on strike having balloted there in August, September. They've actually come to an agreement. They had, I think, sought something around a 25% increase in payments, and they were offered 15%. And by, I think, when they balloted the proposal to increase fees by 15%, 57% of barristers agreed to it. It still seems to be controversial in the UK, but they achieved something by virtue of the strike. You're right, here in Ireland, the fees were, I suppose, cut in 2008. I think there was a second cut in 2011. They have not recovered to the pre-2008 levels. I think other, say, aspects of public funding that was cut around the same time have actually been brought back up. So it is, I suppose, it has not been reinstated. And also, I think by international standards, criminal legal aid would be considered to be underfunded in Ireland, particularly in regard, by comparison to our neighbours. So if they were increased, having already been better than us, I suppose it reflects that we're particularly low level. And for younger practitioners in particular in criminal legal aid, as a barrister in the district court, they are going to court to do a case to remand it for as little as €25.20. Or if there is a guilty plea and the case proceeds to sentence, for €50.40. Or if the case is a full hearing for, I think, a little over €67. So it's hard to make an income at that level.
It has been ever thus, though, hasn't it? In terms of, junior barristers coming in and splitting fees with solicitors, etc. That's been there forever, even before these deductions that were brought about by the economic collapse. And it's always been wrong, hasn't it? It's always been wrong.
I think it's something that has probably been a feature maybe since the late 90s.
Okay.
And what I suppose at that stage, the idea was that, a junior barrister would get some kind of experience and a bit of a beginning at cross-examining and doing things themselves before graduating on to the higher courts, the Circuit Court, the Central Criminal Court, the Special Criminal Court, the Court of Appeal, the Supreme Court. So
you need to learn your craft, of course,
exactly,
and that was a great way of doing that.
But what is happening is that people are effectively staying in that court for a very long time before graduating, and the fees are very low. And what we've also had since that time is there's been an explosion in criminal legislation. There has been an explosion in, I suppose, disclosure issues and the complexity of cases that are before even the district court now in comparison to the late 90s. It's like night and day.
Yeah.
And I think there are effectively more district courts as well, aren't there? I mean, solicitors effectively have to divide their practices between more courts, whereas there was a time when one solicitor would go into a court and basically deal with a lot of the cases there. Now they have a number of barristers in a number of different courts.
Well, I think that presented an opportunity for people starting off that a solicitor couldn't physically get around everywhere they needed to be. So barristers, of course, have an appetite to learn and work and earn money and to, be a part of the administration of justice. That's what we're trained for. But what has tended to happen is that it's just become a very poorly paid vocation, and people are finding it hard to make a living. And like everybody, you have to make ends meet. And if you're at this for a number of years, there's a high rate of attrition. And I suppose the end point of that is that you want, and we all want, because, if it was your brother or your first cousin or your best friend from primary school who had been charged with a criminal offence, and you knowing them felt that there's absolutely no way that they could have committed this, and you feel very strongly about that, you want them to be represented by the best person with the best experience. And if we don't, the system is always evolving. You need young people or young practitioners, new practitioners, to learn their trade now, so that in a few years they are at the peak of their game, that you get the absolute best people with the highest experience.
Absolutely. It's incredibly important work. And across the board, at all levels within the court system, criminal practitioners do incredibly important work. So you saw your colleagues across the water in the UK. Now, as you say, it's slightly different to here, and we know that. But is there going to be any gatherings with placards and, senior criminal barristers gathering around burning bins to keep their hands warm as they protest up and down outside the court? Is there talk of taking it to a different level? I know the Bar Council are making a lot of representations on your behalf. I know as a lobby group you're very good and you're in contact with the Minister of Justice all the time. Does it need to go to a different level, or is that the chat down in the tea rooms down in Phoenix Park?
I'm not a spokesperson for my colleagues, so I won't deign to sort of make a definitive statement on that. That would be wrong.
Yes, of course.
What I can say is that there has been, I suppose, an increase in momentum about the dissatisfaction about this, and maybe some possibly sort of creeping efforts to raise the issue, to publicise it, but also with an effort to engage always with the ministers, the relevant ministers, with the view to see if something can be agreed. Because ultimately a strike really is something that we would, and again, I don't want to talk for my colleagues, but I would say that a strike is something that people would be cautious about. It's, I'd say, a measure towards last resort, if
Absolutely.
not last resort, because ultimately our work is to be part of the administration of justice. And if we are on strike, for example, that means that
people are being denied representation.
Yes, and on the other side, victims are affected because the case where they wanted to give evidence about something that happened to them doesn't go ahead.
It would be very sad if that happened.
So that is not something that people want to rush into. But I suppose, like all options, it's on the table. But this is something, I suppose, that's ongoing. And we'll just have to see what happens over the coming weeks and months on that.
Okay, and can I just ask you, just a final kind of area for me, just in terms of lists and the list system down in the criminal courts, are things moving along nicely? Is there enough judges? Do you feel there's more judges required, or are cases getting on within a reasonable period of time?
Well, like everything else, it's been affected by COVID, and undoubtedly there's across the board a shortage of judges. And I think that that's something that, the judges speak of. I know that the new president of the High Court, David Barneville, was talking about that in the Irish Times over the summer. So that is something that comes up. And, I think there's certainly work for more judges. Are there delays? Yes, certainly at the moment. If you are a person who comes before Dublin Circuit Criminal Court and you want a trial date for whatever matter you have been accused of, if you're on bail and there's no particular reason that it needs priority, you are looking at a trial date at the end of 2024 at the moment.
Wow, okay.
So
that's a long time away.
It's a long time away, and that's with the best will in the world.
That's the Circuit Criminal Court.
Yes.
And the Central Criminal Court, I think, is similar.
Central Criminal Court, it varies. I don't think because the Central Criminal Court sits around the country and deals with cases in, Cork or Limerick, there's always a possibility that those cases can move. My experience is that the delay is nowhere as bad in the Central Criminal Court, sure. But the difficulty in the Central Criminal Court is that you might get a trial date. Let's say, for example, a trial date has been set a while ago, close to a year ago for November, and then everybody assembles on the date, but there's no judge available. So then you may not get the case on and it might have to go back. That is something that happens, and I suppose that happens in all trial dates, but the actual setting the trial date it's not as bad as the Circuit Court, sure. Certainly in Dublin, but there is that difficulty that you can't be certain that the case will get on, because judges, there are only a certain amount of judges, and also cases have to be prioritised. Yes. So judges will have to hear whether somebody's in custody, whether there might be a child complainant, it might be a retrial, there may be different features that might merit something, leapfrogging other cases possibly, and getting ahead because of particular features.
But as you say, for anybody, whether they're accused or a victim or an alleged victim, to have to wait effectively 2 years for the case to come on is really quite considerable.
So the message today is we need more judges. Not the first time that's ever been said on a legal show, but anyway. Catherine, thank you. This has been absolutely brilliant, and you've addressed everything so comprehensively and brilliantly. We have one final question, or two final questions actually. One, did Mark tell you about the book? What book are you going to recommend? Yes. Legal book.
So I had to think about this, and I wanted to pick. Has to
be a thriller.
I actually have 4. So I have
4. Excellent.
4 Irish writers. So I thought that, and I try to keep it gender balanced. So retired Judge Gillian Hussey has a book out recently on her time as a district judge, and the name now has totally gone out of my head. The bench is mentioned on it.
It's well known. We can put that out. No, so, great choice.
And also then the second book that I recommend for somebody who was interested in maybe understanding the sense of sexual offences and consent and the difficulties around that. It's a really good book by Louise O'Neill called Asking for It.
The writer, she's a columnist with the Sunday Times.
That's right. Turned into a play as well.
That's correct, yeah. And then on the other side, 2 of our colleagues, Michael O'Higgins, senior counsel, has written a book called Snapchats.
Is that a novel?
Sorry, it was Snapshots is the name of it. It's a fiction.
Yes, fiction, yeah.
It's not Snapchats. I said to him that should be the sequel. Snapshots is the name of the book. Snapchats is not written, but should be, I think. And then the other book is by Pat Marinan, and he wrote a book called Scapegoat. And those two books are fictions, but they are interesting from the point of view of just seeing a little bit about investigations, and there's a little bit about the courtroom, and because they're written by eminent criminal practitioners with a real sense of this, it's just interesting to see how, they, and I mean the works are entirely fictional, but that they bring that thing to life in a particular way. So
wow, that's fantastic. But you're right, it is fiction, but it's coming from people who are experts in the field. So everything they write is substantive, because they will know that. What about a movie? Did you think of any movie? Are we putting you on the spot there? 4 books are, you've done more than enough with 4 books. So sorry, I'm being very unfair.
Has to be up there.
You can't handle it. You can't. Go on, say the phrase.
I wouldn't do justice. But
all right.
that has to be up there. And I mean, if you're looking for TV shows, like Rumpole of the Bailey is still excellent.
Yes,
I
very
loved
special.
Matlock growing up, but Matlock does not give a true representation of, how much work goes into these things, because Matlock always seemed to think of something in the spur of the moment, whereas the reality is it's about, 1 o'clock in the morning, buried deep at page 408 of 600 pages of disclosure, might find something of use for your cross-examination.
I think a lot of us watched the movies and said, oh, the law, it's going to be so sexy and so much fun. And it is at times, but maybe it's not always like it's represented in Hollywood. Katherine, thank you so much for coming in and being a guest on The Fifth Court.
Okay, I'm sorry, I didn't remember the name of the book.
Lessons from the Bench.
Lessons from the Bench, yes.
The Fifth Court is adjourned until next week.
So that's all from this edition of The Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guest, Barrister Katherine McGillicuddy, for coming in to us today and talking about all things criminal. Really, really fascinating interview. I would also like to say a huge thank you to our producer, Conal O'Morine. Thank you, Conal. And to the Dublin South podcast studios for recording this show and doing such a wonderful job. And Peter Rice, our sound engineer in particular. If you have any comments or any legal stories that you would like to raise with us, please contact us on our website or on LinkedIn. And Mark, as I said, we're still trying to build our audience. Last week we were telling everybody about a chart position. I think we've held it. Have we held it?
I haven't checked in the last 5 minutes, but
we need to see top of the pops.
If anybody thinks that their friends or colleagues would be interested, to please share on the appropriate social media forums.
Keep pressing that button or whatever it is. Okay, so that's it from myself, Peter Leonard, barrister.
Myself, Mark Tottenham, barrister and editor of Decisis.ie.
Until next time, goodbye.